Ladies and gentlemen, if we may bring this meeting to order, please. This is the 93rd meeting of the Standing Committee on Public Safety and National Security, and for the first hour, we have the Office of the Communications Security Establishment Commissioner, the Honorable Jean-Pierre Plouffe, and accompanying him is Gerard Normand and Mr. William Galbraith. So, as you are a frequent person before this committee, I'll let you go and make your opening presentation, and then, as you know, members will want to ask questions afterwards. So we look forward to your presentation, Mr. Plouffe. Thank you.
Thank you, Chair. Alors, Monsieur le Président, Mesdames.
Chair, honorable members, I am pleased to appear before this committee once again today on the subject of Bill C-59. I am accompanied by Bill Galbraith, on my right, the Executive Director of my office, and Gérard Normand, Special Legal Advisor. I have been the Communications Security Establishment Commissioner, the CSE/CSEC Commissioner, for over 4 years, and I'm responsible for reviewing the activities of CSE to determine whether, first, they have complied with the law, including, of course, protecting the privacy of Canadians and persons in Canada. Generally speaking, I am a retired judge of the Superior Court of Quebec and of the Court Martial Appeal Court of Canada. And as I've said often,
Alors, lorsqu'on est un juge à la retraite, il faut pas s'attendre.
So a retired judge, of course, isn't 40 or 50 years old. You have to be at least 70, 75 to be a retired judge. So that would explain why I am a senior person here. As I've mentioned, the law requires that the CSC commissioner be a supernumerary or retired judge, so a part-time or retired judge of a superior court. My current term expires in mid-October of this year, 2018.
Bill C-59 receives royal assent and Part 2 enters into force. My role will change into a completely, and I emphasize completely, new function for intelligence accountability in Canada. Indeed, the CSC Commissioner will no longer perform after-the-fact review of CSC activities. The Intelligence Commissioner, or the IC if you prefer, will have a quasi-judicial role of reviewing on one part and approving on the second part authorization issued by ministers for certain activities of CSC and CSIS before those activities can be conducted. This specific role will be to determine whether the minister's conclusion to authorize the activity were reasonable. This is the test that I have to apply, reasonability. In essence, this is similar to the function performed by a court of law when undertaking what we call a judicial review. This is, in my view, a critical role intended to provide a quasi-judicial review of intelligence agency activities that may have charter and or privacy implications. La partie 2 du projet de loi C-50.
Part 2 of Bill C-59, the Intelligence Commissioner Act, expressly provides for the transition of the CSC Commissioner into the role of Intelligence Commissioner. The functions of post-facto review of CSC activities that I now perform will be assumed by the new National Security and Intelligence Review Agency, also proposed in Bill C-59.
requires the Intelligence Commissioner to be a retired judge of a superior court, which is appropriate, in my view, given the quasi-judicial function of this new position. However, this bill does not include the possibility of appointing a supernumerary judge, as is the case now with the National Defense Act for the CSE Commissioner. I believe this bill should retain the possibility of a supernumerary judge, in part to ensure a broader pool of potential candidates. I was indeed a supernumerary judge when appointed CSE Commissioner 4 years ago, and a short time after, I fully retired as a judge. So the problem is the following. The pool of candidates for this job, the new Intelligence Commissioner, the pool is very, 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 very narrow. You must find a retired judge who has normally the proper background to be appointed. Example, a background in security matters or a background in national defense matters. So the pool is very, very narrow. So that's why I'm suggesting that we should keep in the bill what we have in the National Defense Act with regard to the appointment of the Intelligence Commissioner. In other words, a judge could be appointed, a supernumerary judge could be appointed as the IC, and then would retire maybe a few months later. It would be a transitory measure. I can agree and I can see that if a sitting judge would remain the Intelligence Commissioner for years, it might have some problems with regard to conflicts of interest and what have you. But I think that for a transition purpose, it might be very, very useful. I submitted previously to this committee a written copy of substantive proposals for amendments to Bill 669. Those comments were sent to your chair on the 6th of December 2017. I am also submitting today a list containing additional substantive and technical proposal that I sent to Ministers Goodale and Sajjan. I think you have a copy of those comments before you. And I will highlight a number of these in my remarks. Le processus que le gouvernement choisit
The importance of the process the government has chosen to follow for this bill is, as stated by Minister Goodale, to allow new ideas and alternative suggestions to be presented before second reading in the House.
Changes I am proposing for 3 parts of the bill, that is Part 2, the Intelligence Commissioners Act, Part 3, the CSE Act, and Part 4, amendments to the CSIS Act. While I am of the view that the proposed legislation is generally sound and that it addresses most of the recommendation made by me and my predecessors to amend Part 5.1 of the National Defense Act, I am also of the view, following in-depth analysis and discussions with officials and agencies directly involved, that certain amendments should be proposed. Among my substantive proposal, I will describe 7 that I consider the most important. First, I believe the Intelligence Commissioner should be involved in approving authorization for CSE active cyber and defensive cyber operations, which may also implicate privacy interests. Some commentators have remarked that this is a new and very broad mandate for CSE and that it is too permissive. By comparison, the CSIS Act requires CSIS to go before a federal court judge, in some instances, to have a warrant issued for similar activities. Deuxièmement,
Second, as the bill is written currently, the minister's decision to extend the validity of a CSE foreign intelligence or cybersecurity authorization for an additional year does not have to be approved by the Intelligence Commissioner. I believe the Commissioner should be involved, given that he was involved in approving the initial authorization. Otherwise, in effect, the authorization would be for 2 years, and that isn't what is in the legislation. Right now, it is for 1 year maximum, but if in practice the minister almost automatically approves the extension or renewal, then the commissioner would be faced with a 2-year authorization and not the 1-year one.
Authorizations for CSE issued by the minister for purposes of foreign intelligence or cybersecurity should also be reviewed by the commissioner immediately after they have been issued. This would be similar to the approach that exists in the Investigatory Powers Act in the United Kingdom. Under the UK legislation, the period of validity for these emergency authorization is 5 days, the same validity period as in Bill C-59. However, in the UK, the Judicial Commissioner must review and approve these authorizations within that time frame.
Unfortunately, we're going to have to. Are you able to wind up your final 4 points in less than 30 seconds?
Well, if you give me maybe 2 or 3 minutes, I think I could do it.
My only problem with that is that when I give you 2 or 3 minutes, then I get grief from all of my colleagues. So I can give you a minute, and
okay,
you can
I'll try
wind
to
that
finish up the proposal, because I know one of the questions will be will be on those particular points.
Okay.
I've been warned.
Okay.
So, okay.
Thank you.
Quatrièmement, j'estime que le commissaire devrait.
Fourth, I also believe that the Commissioner should have the authority, when engaged in the approval and review process, to request clarifications about the information provided that was considered by the Minister in making a decision. Without this ability, the Commissioner, if not clear on some of the information, may well have no option but to determine that the Minister's conclusion to authorize an activity was not reasonable. Fifth,
Conditionally approve an authorization, subject to the minister agreeing to incorporate a condition identified by the commissioner. 6, and I got only 2 left, le commissaire au renseignement.
the Intelligence Commissioner should prepare a public annual report to the Prime Minister to be tabled in both chambers of Parliament, and the report would emphasize the independence of the Commissioner and help enhance transparency.
Decision-making authority should be inserted in the proposed Intelligence Commissioner Act for carrying out the purposes and provision of the Act. Alors, je vous remercie de m'avoir.
Thank you for this opportunity to be able to appear before you today, and we will be pleased to answer your questions. Thank you, Mr. Chairman.
Thoughtfulness and preparation. I'm going to turn now to Mr. Spengelman for 7 minutes, please.
Oh, I don't think that's the agreed upon order, Mr. Chair.
Oh, well, you must have a different list than I do.
Ms. D'Abruzzo.
Then. Thank you.
Thank you very much for that presentation. It was very interesting, because for me, one of the things when I've talked with people in my community about what they wanted to see in our national security regime was better oversight. That was a big focus of it. And so hearing a bit more about what your ideas are and about how this bill goes towards that end is very helpful for me, and I appreciate that. I was looking at a report that was prepared by the Citizen Lab of the Munk School of Global Affairs, and it had several different recommendations that they made in respect of the Information Commissioner and oversight. And I was wondering, given that you've been involved in the system a little bit, you understand how it works, if you might be able to help me, give me some insights as to the workability of some of these. One of them, I think, touches on one of the last points that you were raising. It might fit in with it, which was that they recommend that that an emergency authorization under Section 41 be reviewed ex post by the Intelligence Commissioner. So how does that fit in with your suggestions? Do you think that that works well with what you've proposed today? It's like,
the General Counsel to answer. I did touch upon that subject matter
Yeah.
in my introductory remarks, but I'll ask Maître Normand to reply
No,
to.
essentially, they're not maybe the level of detail that we provided because we based it on the UK legislation, but the idea is the same, that basically it would enable the minister to make a decision in exigent circumstances, but that would be reviewed within 5 days by the commissioner. And then, depending on his review, depending on his decision, then there would be an impact or not on the ongoing authorization. But in essence, it's basically the same thing that we're
the
proposing.
same idea.
Yeah.
Perfect. The other suggestion was to require written reasons when approving an authorization, not just when an authorization is refused. And what would you think about that as a suggestion?
Well, the bill actually provides that if the IC, or the Intelligence Commissioner, turns down the request submitted to him by the minister, or his conclusion, I should say, then he has to give reasons. On the other hand, if he approves the authorization issued by the minister, he doesn't have to provide reasons. As a retired judge, I don't mind providing reasons. I've been doing that all my life. When you issue a judgment of any sort, you do provide reasons. So I'm not against that suggestion that even if I approve the authorization issued by, or the conclusion reached by the minister with regard to the issuance of an authorization, that the commissioner should provide some reasons. Obviously, those reasons would be rather short, as opposed to where the conclusion of the minister are judged unreasonable by the IC. But I'm not against that suggestion.
I think actually reasons, especially in the first few years, would be helpful for the agencies as well to see where the commissioner is coming from in the way of thinking within the reasonableness process.
All right. Well, thank you for that. You had mentioned in your remarks that you saw the Information Commissioner being involved in active and defensive cyber operations authorizations. I was wondering if you could elaborate. How would you see that role? What would you see that how that would look?
This is a complex matter. I mean, those are complex provisions within the bill. Those provisions concerning the active and defensive cyber operations.
I have the bill in front of me, so if you want to, run it with me, I'm happy to do that.
In essence, what we are, what I'm told, or what was explained to me, is that the IC will not have a role to play because, contrary to where information is collected, and in cyber, active and defensive operation, cyber operation, no collection will occur. So they suggest that there is no charter or privacy rights that would be affected by these techniques that will be used outside of Canada. This is with regard to CSE. Unfortunately, I don't necessarily agree with that view, and neither is the Department of Justice, who is the legal advisor to the government. And I'm quoting from the Justice legal opinion, page 9 of a document entitled Charter Statement - Bill C-59. And it's a short, but it does explain my position. And I'm quoting: the provisions authorizing active cyber operation would not by definition engage any charter rights or freedoms. However, specific activities authorized under this scheme could potentially engage rights or freedoms. The consideration that support the consistency of this aspect of the mandate with the Charter are very similar to those supporting the consistency of the defensive cyber operations mandate. One difference is the distinct purpose of active cyber operations which would be to further the government's compelling objective in relation to Canada international affairs, defense, or security, unquote. So, although no information is collected, privacy communication of people will be disrupted, influenced, interfere with, and this could very well, in my view, affect Canadians the same way that collecting inadvertently information on Canadians abroad happens. In my view, there should be no difference between collecting communications of Canadians abroad or disrupting and interfering with communications of Canadians abroad. So
The only reason I'm jumping in is because I know I'm
Yeah,
about
so
to run out
Ines,
of time.
this is my answer.
So I just wanted to know how you would see, what would you want to see as far as the
Yeah.
Information Commissioner's role then?
So I think the IC should be involved with regard to those operations.
Thank you, Ms. DeBruzen.
If I may just add, the role would be a similar one, reviewing and approving the same, which would be the same scheme as the other authorizations, basically. So you would look at the facts presented to ministers. It would look at basically what the factors in the statute require for the decision to be made, and ensure that the facts support that.
I can see that I'm going to have some difficulty reining in time here. This is an important discussion. Before I turn over to Mr. Mutz next, you were quoting from I wonder if you could make that available to the committee, if it's not already available to the committee. Oh, okay. So it's in a bulletin.
I'll leave it with you afterwards.
Okay. Okay.
No
Well, thank you
problem.
for that. Appreciate it. Mr. Motz, 7 minutes, please. Okay. Thank you.
Thank you, Mr. Chair, and thank you, Commissioner, and your team for being here today. I understand that Section 61 of the CSE Act provides Cabinet the authority to change parts of the Act, commonly known as Henry VIII Clause. Section 61.
The CSE Act?
61 of CSE Act.
61?
Yes, provides Cabinet the authority to change parts of that act, and it goes back centuries. Now, why is it necessary for Cabinet to have the ability to take on really the role of Parliament? And a follow-up to that is, if this is what Parliament is doing, this is what Cabinet is going to do, shouldn't some of the things that they want to change, the legislation, the parameters for regulations, and anything about that put in regs, so that if we know that the cyber world changes quickly, and if there's a need to add some flexibility in the legislation, wouldn't it be better, rather than giving a Cabinet that authority, to put it in the regs to allow that? What's your thoughts on that, sir?
The reason I made that suggestion with regard to the possibility for the Governing Council to make regulations is the following. When the bill is passed and has received royal assent, if you look in one of the provisions of the Act, I don't recall the exact section number, it says that the minister concerned must provide to the IC, the Intelligence Commissioner, all the information that he had before him. Okay? So this is not defined. We don't know what exactly the legislator is talking about. Are we talking about briefings? Are we talking about reports? We don't know. So in my view, a regulation could be written where the IC's office, with regard to the minister's office, would lay down what would be required to be transferred to the IC with regard to this quote-unquote all information. This is similar, for those who have a legal background, to the rules of practice of a court of law. Okay? So we talk about procedure, we talk about, in this particular case, what this all information should be. And I think this adds flexibility to the bill. Okay? This is... how should I say? En français, je dirais la cuisine. I mean, you got to...
This is the just kitchen stuff. This is the administrative stuff.
You need rules of practice or equivalent.
So then, if I understand you right, you're suggesting that there might be some change necessary to Section 61 to put those parameters, if you will, to provide clarity in the regs and not allow or not provide a provision for Cabinet to have that sole authority. Am I hearing you correctly?
Yeah.
Okay, thank you. Now, one of the things that I'm curious about is, based on your experience in this role and your past experience on the bench, your thoughts on the utility of offensive cyber attacks. I know that's something that some people have some concerns about. But if we're talking about our national security and public safety, what are your personal thoughts on the act allowing offensive cyber attacks or cyber operations?
I think this is the. I'm not trying to evade your question, but I think it's a question that is more appropriate for CSE. But all I can say, though, is that this is a very broad mandate for CSE, and I think it's reasonable for commentators, legislators like you are, to raise the point and ask questions. Do we, in essence, do we need that type of technique with regard to security? Do we need that? And if so, how should it be? How should it be limited, or should we have oversight with regard to those powers? Like I say, it's very broad.
And you mentioned CS or CSIS. So how do you think the coordination of your work between CSE and CSIS will occur to ensure both agencies don't overlap in your effort to prevent attacks? How do you coordinate those things now, and how do you see this act enhancing that moving forward?
Like you may realize, the first task of the IC would be to review and approve the authorizations that are issued by the respective ministers. That's the first thing. On the other hand, and again, it's similar to what we a court of law would do. You need expert advice at times. Okay, so that's why in my office I'll need experts. In other words, people that know what CSIS is doing, also people that would know what CSE is doing, and to advise me accordingly. A bit like when you're sitting as a judge, you have expert witnesses that come to court to advise you because the judge is not an expert. So I feel that in my office, we are restructuring right now, and I do have those type of experts in my office.
Oh, thank you, sir. One last question. I have limited time. So you've already given us recommendations, 7 recommendations you'd like to see, and some technical proposals you have as well. In an ideal world, when you have some flexibility given your role, what would you take out of the bill? And what would you add that you maybe haven't mentioned yet, that you haven't had the flexibility to mention?
In my introductory remarks, I made 7 suggestions, substantial suggestions, and those are contained in the document that I sent to the chair, and I did underline 5 or 6 of those in my introductory remarks. You want me to repeat that? I think no. That's fine.
Okay, so one last question. So how do you think we do currently in comparison to our Five Eyes partners in combating cyber threats relative to our Five Eyes? And will this C-59 make us even more, I guess, nimble to deal with that?
That's an extremely broad question.
No, we can.
And we've already run out of time. But can you do it in 15 seconds?
Yeah. Okay. Essentially, we had a look at the legislation in 4 other countries. Our understanding, and subject to the view of others, is that it's mainly aimed at defense activities and providing assistance to other agencies. Section 31 provides the ability for CSE to do things on their own, to disrupt without any, for the purpose of international affairs, defense and security, but not necessarily in an assistance role or defense role, which they can do as well. But there seems to be something different with respect to the other countries.
Thank you, Mr. Motz. Mr. Dubé, 7 minutes, s'il vous plaît.
7 minutes, please. Thank you, Mr. Chairman. And I would like to thank our witnesses for being here this morning. I have a quick question. I have the impression that you may not have too much to say on this, but given the lack of time, and I don't mean this as a criticism, but these are extremely important changes being proposed. And you mentioned 3 different parts of the bill, 2, 3, and 4, that need changes. Do you not think that if we are creating new structures and broadening significantly the powers of CSEC, do you not think that we should split that up, that we have this huge 138-page bill? Well, I think this is a question really for the government. I know that there has been discussion on whether or not the bill should be split and the different parts reviewed separately. The government decided against that, and that the bill should be kept as a whole. It does make it more complex, but that doesn't mean that we can't make suggestions for needed amendments. Of course. In the answers you've given to some of our colleagues concerning the mandate of CSEC, we heard from Ms. Bossenmeyer, and she talked about subsection 24, which has exception, and talks about publicly available information, and the following subsections as well were of concern. She said that only foreign people and entities were in question here. So do you feel that the mandate here is appropriate? And given these exceptions, without telling us really why they are being proposed, and further back it says that the minister can add certain infrastructure, telecommunications infrastructure, and so on, without necessarily justifying the broad scope of these provisions. So it's really a comment, but do you feel that the new mandate is sufficiently justified? We don't have a lot of information. Well, CSEC's mandate is not to target Canadians and people in Canada, so there's no change to that. CSEC, under the legislation that exists, targets foreign entities. There's no change to that. If CSEC decided to target Canadians, well, then that would be illegal activity. That's a fact. But it is therefore all the more important, I feel, for the oversight bodies, whether we're talking about the new proposed committee or CSIS. I think the Information Commissioner's name should really be the Judicial Review Intelligence Commissioner or something like that. But in fact, the activities are partly secret. And if we have an oversight committee and we want to be able to maintain public trust, then we need to have the measures in place. Well, I realize that the mandate is not to target Canadians, but I think that there are concerns in this bill in that regard. I just want to go quickly here, but of course I want to make it easier for the interpreters. Just the bill says that the government can make changes to include communications infrastructure and other exceptions. So although the target is foreign entities, we have designated infrastructure that would be used by Canadians. Additionally, in subsection 23, there are exceptions that would target Canadians, And then Section 24 says, regardless of what has already been said, then there has to be concern for information available to the public. That can be taken into consideration. And later in the bill, it includes information that may be used by Canadians. So we're talking here about sections 27, 28, and 41. So yes, only non-Canadians are targeted, but there are a lot of loopholes here that could affect Canadians because of these exceptions. So when there is sharing information between Canadian bodies and others, like Americans, well, what I would say is perhaps my colleagues could better answer this question, but I can say that currently and under the new legislation, if it is adopted, every time CSEC wants to target entities or persons abroad, and if there are incidental interceptions of Canadians, any communications involving Canadians, there has to be authorization from the minister. The minister personally has to authorize those activities. And once that has been done, then there is oversight by the oversight bodies afterward. So we have to make sure that what the agencies are doing is legal and does not compromise Canadians' privacy. So I understand from your question that Canadians have a concern because some of these activities are secret. Of course, they're intelligence activities.
Picard.
Merci.
7 minutes.
Passionnant. Merci beaucoup. Je vais aller
Thank you very much. I will ask short questions because I want to give time for answers. Mr. Picard, yes? Perhaps because I'm older, I am having a little bit of trouble hearing you, but if you could just speak up a little bit. Thank you. Your point 6, the Intelligence Commissioner should prepare a public annual report to the Prime Minister. I have a question about that. Before, did the report go to Parliament or to the Minister? Right now, the CSEC Commissioner, so me right now, produced an annual report to Parliament through the Minister responsible, and the Minister had to table the report to both houses of Parliament within a certain timeline. Now, what I'm proposing here is, since the Prime Minister is responsible for or recommends the appointment of the Intelligence Commissioner, the report should go to the Prime Minister. And right now it is the Defense Minister, but the Prime Minister would have that same requirement to table the report in both chambers. Right now, the bill doesn't mention anything about annual reporting. And now, why is this important? As I point out, it emphasizes the independence of the Commissioner, and it's a way of ensuring public trust, because the public and commentators want to know what's going on, want to know what the Intelligence Commissioner is doing. So the version of the report that is provided to the Prime Minister would have to be amended so that it could be made public. No, that is done ahead of time. So we could really produce 2 reports. One would be classified, and that would go to the Prime Minister or the Parliamentarians Committee, and a public report that would be made public. That's important for public trust and also for accountability. Another specific point is section or point 2 in your introduction here. you talk about the additional year, an authorization for an additional year. So if the Intelligence Commissioner already authorized or approved the activity, why would another authorization be required? And if during the year there was a change of heart, then there would have been some concerns ahead of time, I would think. My philosophy is as follows. If the commissioner has to approve the initial request, I don't know why the commissioner would not also be involved when there's a request for a renewal for an additional year. Why is there this request for an additional year? There must be new facts, and therefore there has to be a request that is submitted, and the minister has to decide whether the agency's reasons justify the authorization of an additional year. So I don't understand the reasoning. That is why the commissioner would be involved initially, but not for the renewal. It would be like going to court and you ask for a search warrant. A year later, you would like the warrant extended. You would have to come back to court and make that request. Thank you. One last point. In your first proposal, certainly I understand we have no, you talk here about active and defensive cyber operations. I just have a line of questioning, but I'm going to start with a different point. Is an active cyber operation one that targets a foreign country? I think CSEC could better answer the question, one of my officials here. So is this is a legal question, it seems to me. So regardless of the legislation, if a body, an agency reports to government, created by the government, targets a foreign agency, just like we can be victims of foreign organizations, then that is a defensive operation in that case. Do you feel that this... does this constitute an act of war? Well, if the government decides with CSEC and other agencies that for national security reasons, for international security reasons, this is essential, that CSEC needs these powers, defensive and offensive operational powers. This is very broad, and I think that there can be implications for the charter, for Canadians' privacy, and therefore we need oversight by an independent body. And right now, that is the Intelligence Commissioner. So I don't understand why the Intelligence Commissioner would be excluded from this oversight function. And I put this in my comments. I think that the Department of Justice is in agreement. If we have implications for the Charter and Canadians' privacy, I think there needs to be oversight. The government and Parliament enacts the legislation that it wants to, and if there is also the possibility of giving federal court judges more powers. This is something we wouldn't have seen before. The main reason here is that these new CSEC powers will become part of our legal system. And of course, we've got the charter issues and so on that have to be looked at as well.
Mr. Paulus, 5 minutes, s'il vous plaît.
Mr. Paulus. Thank you, Mr. Chairman. And thank you to our witnesses for your document that you provided, which is quite complete. Bill C-59 is a large and complex bill with very important issues in it. Now, I want to come back to the issue of authorization. Right now, we have cyber threats, and we know that we need a great deal of resources to deal with these cyber attacks. So the active cyber operations are important, and we know that there are a lot of colleagues that have to be involved. There are a lot of computer operations that have to be done. And we had at the Defense Committee this morning, we had people that deal with cyber attacks and those issues, and they talked about protection, and they deal with CSEC on these matters. And in Bill C-59, authorization is required from the Foreign Affairs Minister, and then the Intelligence Commissioner would be involved if you have your way. Isn't that too many people? Well, it's hard to answer your question because I don't know all the operational steps involved, but from what I understand, given that CSEC targets foreign entities, the idea, I think, was that we have active and defensive cyber operations, and the Foreign Affairs or Global Affairs Minister should be involved. And so there should be either a request or approval at that level. So I don't have any problem with this. I have a problem, though, with the idea that the Intelligence Commissioner would not have a role in providing oversight because we have charter and privacy issues. Now, are there other types of operations that could be undertaken abroad? For example, telecommunications, information sharing. I'd like to have some examples, because right now it's hypothetical, it's theoretical, when we talk about what Canada might do in terms of active cyber operations. Section 27 of the bill, 28, deal with this. You talked about 41 as well, with active operations. We're not there to collect information. We are only there to disrupt communications. There might be military aspects for this, and obviously the military would use the operations they feel necessary for their aims, but CSEC would not be involved in that. So under provision 31, CSEC could interfere with communications in the interests of international security. So, and international affairs, that can mean a lot of different things. The commissioner would be involved in similar decisions because when it comes to collecting information, there could be similar activities, and there would be an oversight role. So we don't see why the Intelligence Commissioner would be excluded in the case of active cyber operations. I just have 1 minute left. Your proposal number 7 is important for the Act because the value of the information to be obtained has to be in keeping with the needs. Thank you.
I should stop hitting that. Thank you, Chair. Thank you, all of you, for being here today. It's been quite insightful, and appreciate your recommendations that you're providing to us as well. Can you hear me okay?
Bit louder.
Okay, the sound in this room is terrible.
Good, yeah.
So, as you know, the current scope of CSC's mandate is to acquire and use information from global information infrastructure. Under the current information infrastructure, there really isn't clear direction on how to address the possibility of a Canadian citizen or someone who's residing in Canada from having their information collected. And I'm wondering if you see a benefit in recommending that C-59 be amended to clarify ministerial authorization be required when CSC does acquire information from or through global information infrastructure where a Canadian or someone residing in Canada has a reasonable expectation of privacy.
Could you summarize your question? I'm sorry, I'm not, because I didn't catch exactly what.
So if there's a Canadian or someone who is residing in Canada, here, let me try and move closer. If there's a Canadian or someone who's residing in Canada who has an expectation of privacy in their information, they're not really covered. Would you think that it would be beneficial to have ministerial authorization involved when you're collecting that information?
You mean with regard to CSC?
Yes. Yes.
Yeah, well, according to the actual mandate and also the mandate that is provided for in the bill, Bill C-59, CSC cannot target Canadians or person in Canada.
Canada, but what
no,
if
it cannot. It can only target people or entities abroad.
So if I'm away on holidays in Scotland,
well, you're abroad.
So that, but do you think there should be authorization for Canadians when they are in that situation then?
Well,
CSC can't target.
sorry?
CSC can't target Canadians.
No, CSC cannot target Canadians. Go ahead, Bill.
It's if you're on holiday in Scotland, CSC would only be able to intercept a communication involving you if they were targeting a foreign entity abroad. And all the other privacy protections that apply would be, and that's what the Commissioner would be looking at. The details, it may be questions that you want to ask and hear in much greater detail from CSC itself, a question like that.
In other words, it's only, in your example, it's only incidentally that your conversation example would be intercepted because maybe you are talking with somebody else in abroad, another entity, and CSC wants to target that other entity, not you. But if you happen to be there, this is what we call incidental. It might, while targeting foreign entities, CSC might intercept private communications involving Canadian incidentally. That's why they need an authorization from the minister to do that, okay? Because the prime target is not the Canadian. The prime target is the foreign entity.
Okay. That leads me to, how much time have I got? Publicly available information is one of the things that you're able to collect. And I don't think Canadians understand particularly well how much information how much private information we actually share publicly. So when I'm logging into an app and it says use Facebook, can you buy that information from things like my Facebook picture or things that I might have shared that I don't realize are private?
Okay.
Well, as of now, the definition does cover information that you can buy, and some have expressed the position that it should not be covered. I mean, Pipedia, for instance, the legislation that we have in Canada does not cover that type of information to be part of the publicly available information. That is basically, again, the matter for the government to look at, to decide how wide they want the scope to be. One thing I would say is that if you look at the definition in the proposed CSIS Act, it's even more nebulous because they refer to a section so it's circular, so they're not defining it at all. So for one thing, I think that this committee should ensure that the definition that they will take will apply to both statutes.
Thank you, Ms. Damoff. Mr. Motz, for the final 5 minutes, please. Thank you.
Thank you, Chair, and thank you again for your comments. I want to just ask a question, Mr. Commissioner, with respect to your third recommendation. You are, I appreciate the interest you have on being involved in approvals, and to be able to do your job effectively, you need to be involved in a lot of them. Now, when you talk about emergency authorizations that the minister issues, you suggest that you should also be reviewing those immediately after they have been issued, which is before they're actioned, as I understand this. So if that's the case in something that's exigent, would that not maybe put a further timeline on or a hindrance on the work of the security agency to do their job and maybe prevent imminent threat?
The provision, what we're aiming for would not be to suspend the application of the authorization until the AC has looked at it. It would proceed with this authorization immediately. But the review ex post facto would be to ensure that that decision that was made was reasonable. So it has to be made within the 5 days. So after 2-3 days, if he decided it's not, then it has to stop, but it would not prevent it from starting.
It's similar to what they have in the UK, actually. In other words, the operation is going on, it's proceeding, but within, let's say, for a maximum duration of 5 days. But let's say in this particular case, the IC could intervene after 2 days and 3 days, look at it and say, well, I'm sorry, but what we have done in the last 2 or 3 days is is unreasonable, and it should stop. Or this is the purpose or the gist, if you wish.
Okay, so you're not, if I'm hearing you correctly, you're suggesting that the authorization will proceed in an imminent threat situation. It's a review for the next time.
Yeah.
Okay, thank you. When you look at your resources and you look at what 59 is proposing, do you feel confident in the capacity that you have enough resources to monitor anyone deemed to be a threat, or would those resources only deal with those that are deemed to be a top-level threat?
Bill?
In terms of whether or not we have adequate resources, the transitional clauses in the bill are quite clear. What we have in terms of the Commissioner, the employees, and the appropriation from Parliament all transition to become the Intelligence Commissioner and his office. What are the requirements? The requirements are having intimate knowledge of CSE activities, of CSIS activities. Clearly, we have the knowledge of CSE from the activities, from the work that we conduct currently, reviewing the activities of CSE. But we also have on staff now individuals who have experience and knowledge of CSIS. We had the opportunity to do some staffing over the last year, or since June at least, and we have hired individuals with a knowledge and experience of CSIS activities, as well as having engaged special legal counsel that we have with us here to deal with the complexity of C-59. And as to whether the staff is going to be adequate going forward, there are a number of unknowns in terms of the number of authorizations that will be required from CSIS or CSE. And it's only going to be once the bill is enacted and the activities begin that we'll have a sense of what the volume of authorizations would be. But clearly there was a sense that we've got a reasonable starting point. The drafters of the legislation, the government must have felt that we had at least a good start with what we've got to transition into the new organization.
So speaking about the transition, are you clear or comfortable or understand the impact of the the new parliamentary committee and its role with the intelligence community and CSIS and those operations and how that's going to play out?
We are studying all of the aspects, yes, and following the development of the Committee of Parliamentarians. We are meeting with CSIS and CSE with respect to how they're preparing and keeping abreast to the extent that we can on their work in developing the new authorities that they may have as well.
Thank you, Mr. Motz, and that does bring to a close our first hour for this committee. On behalf of the committee, I do want to thank you for your contributions. As you can see, time is the enemy here, and much of what you raised certainly needs to be thought about extensively by the committee. So again, thank you for your contributions to this study. With that, we suspend for a moment or two and re-empanel as quickly as possible. Call to order this second half of our meeting, and we have with us Mr. Ray Boisvert, who is with the Ontario Ministry of Community Safety and Correctional Services, and Michelle Vaughan, who is with the BC Civil Liberties Association. I don't know which wishes to go first, but whoever wishes to go first, please do so. You have 10 minutes.
Happy to go first. Thank you, Mr. Chair. Thank you to the committee for this invitation. My prepared remarks are about the CSE and CSIS bulk data collection. In his testimony to this committee, Professor Craig Forsays made a very important point about the thresholds for authorization for CSE data collection. In Section 23 of what would be the new CSE Act, it sets out that activities carried out by the CSE in relation to its various mandates must not be directed at Canadians or persons in Canada. This is, of course, a continuation of the current situation in which the CSE is required not to direct its activities in this fashion. Nevertheless, it is well established and conceded that the information of Canadians and persons in Canada is collected because some collection, and by no means insignificant collection, is unavoidable due to the complexity of communications networks. Thus, Canadians' information is collected incidentally or unavoidably. Now, part of the new regime proposed for the protection of Canadians' privacy interests is to require that the CSE seek a ministerial authorization that is then approved by the Intelligence Commissioner. The trigger that initiates this process of authorization and Intelligence Commissioner vetting is where the CSE's activities would otherwise contravene an Act of Parliament. Now, we agree with Professor Forsays that this trigger is under-inclusive, a view that is now echoed by Citizen Lab, the Canadian Internet Policy and Public Interest Clinic, and others. As Professor Forsays notes, there is concern that the proposed threshold would not ensure that the authorization process would, for example, be initiated for activities that incidentally collect Canadians' metadata, which is obviously of critical importance. Craig Forsays proposes a more expansive trigger in which the authorization process is required for activities that would otherwise contravene any other Act of Parliament, or involve the acquisition of information in which a Canadian or persons in Canada have a reasonable expectation of privacy, a threshold that has already been referenced. Now, our problem with this proposed addition is simply this, that the question of what precisely attracts a reasonable expectation of privacy is typically the central dispute in almost any emergent privacy issue. And this threshold would be adjudicated internally by the CSE. We know, not least from years of reports from the CSE Commissioner, that disputes over the interpretation of legal standards and definitions have been of ongoing concern, and national security activities in general are plagued with the secret law's problem of having words in a statute or directive interpreted in sometimes obscure or deeply troubling ways, and ways that may not be unearthed for years. So a trigger that involves a colorable definition is inherently problematic in our view. However, we read the latest CSE Commissioner's report as indicating that the CSE has conducted its signals intelligence activities under just 3 ministerial authorizations since 2015. It appears that these authorizations tend to authorize a broad sphere of activities. Our understanding that the frequency and scope of incidental collection suggests that most or even all of the authorizations are apt to at least implicate Canadians' data. In other words, there are only a small number of authorizations, and almost all are apt to require the authorization regime of vetting by the Intelligence Commissioner. Surely then, it is best and still entirely feasible and efficient to ensure that this authorization process does indeed examine everything that we are hoping that it will, to simply have one uniform process of authorization approval by the Intelligence Commissioner for all classes of activities undertaken outside of the technical and operational assistance mandate, which is, as you know, its own sphere of activities. For everything else, we recommend that the question of threshold be resolved by eliminating the need for a threshold and ensuring that every class of activities authorized are subject to the new accountability procedure of ministerial authorization and vetting by the Intelligence Commissioner. Turning now to bulk data collection by CSIS. It was most certainly our concern coming out of the national security consultation that the government response to the CSIS bulk data scandals, if you will, would be to simply empower the agency to do what it had previously been doing unlawfully, without having a meaningful democratic debate about mass data acquisition in the context of national security. We certainly appreciate that having bulk data collection squarely on a legislative footing does improve transparency, but we are deeply concerned with the low threshold that is proposed in Bill C-59, and that this critically important matter is quite frankly receiving insufficient attention in the context of a large omnibus bill. It is only recently that CERC has done its first ever audit of the bulk data collection programs of CSIS. CERC is of the view that appropriate bulk data collection by CSIS can occur under CSIS's current Section 12 standard of strict necessity for data collection. In our view, it is hard to imagine a body that would be better positioned to assess this, both from the perspective of accountability and respect for the rule of law, and from the perspective of the operational needs of CSIS. CERC's proposal for the standards and criteria for bulk data collection is a three-part test. Clear connection to a threat to the security of Canada, no less intrusive means available, and objective assessment of intelligence value. They're a three-part test. Now you compare that standard with the standard as set out in Bill C-59. C-59 allows CSIS to collect publicly available data sets, with no definition of that term, on the basis of a bare relevance standard. With respect to Canadian data sets, which we need to remember are expressly defined as data sets that contain personal information expressly acknowledged as not directly and immediately relating to activities threatening the security of Canada, the test for their acquisition is simply that the results of their querying or exploitation could be relevant, and that this assessment must be reasonable. It may be argued that this vast scope for bulk data collection is at least mitigated by the requirement for judicial authorization for the retention of those data sets. But rather than significant gatekeeping, this authorization simply compounds the effects of the very low standards that lead up to it. Personal information that does not directly and immediately relate to the threats of security of Canada is allowed to be collected if it could be relevant, if this assessment is reasonable, and if the judge then decides that the data set can be retained on the standard of is likely to assist. These then are the thresholds of what most Canadians would call mass surveillance, and we believe most Canadians would reject these thresholds as shockingly low standards. Thus, a genuine opportunity to meaningfully shape these surveillance practices is being squandered in Bill C-59. The proposed standard is a mass erosion of the privacy protections from the strict necessity standards that currently apply. We recommend that the CSIS bulk data provisions be revised to be expressly within the strict necessity standard, not an exception to it, and the criteria for bulk data collection, such as that fashioned by CERC, is implicitly principled and workable and should be set out within the legislation. Those are our prepared remarks. Thank you.
Thank you, Ms. Vaughn. Mr. Boisvert.
Well, thank you very much, Mr. Chairman. Thanks for this opportunity to speak to everybody here today. As you know, I am the Provincial Security Advisor for Ontario. I began this role in January of 2017. Prior to that, I spent almost 5 years as a consultant to private and public organizations in the area of national security-related risks, including cyber threats. And prior to that, I was with the Canadian Security Intelligence Service, or CSIS, and left that organization in 2012 as the Assistant Director. As a result of joining CSIS at its inception in 1984, I have witnessed a tremendous number of milestones that shaped Canada's security intelligence environment. More specifically, though, it was in regards to the organizations that are central to Canada's threat response. At this moment, we find ourselves yet again at the cusp of change, and obviously important change. Although the CSIS Act has been widely viewed as a model of effective security intelligence legislation, it has required renovation from time to time. Perhaps not so much due to any particular failings, but rather necessity of changing times, socially, culturally, politically, and now more than ever, technically. Of all the elements of import in Bill C-59, it is time to consider essential changes for an organization I did not work for, but with which I maintained important operational connectivity to over many years. It is time for CSE to have its own enabling legislation, as its current mandate is 16 years old. Most critical to that transformation of mission and mandate is the area related to cyber threats. Canada must now join the community of like-minded nations determined to resist the growing threat of globalized criminal enterprise, nation-state directed theft of intellectual property or interference in our society, and the potential for catastrophic destruction of critical infrastructure, be it the result of fifth-dimensional warfare or terror attack. We must connect and support and keep pace with our allies from Australia to the EU, and that they themselves have recognized the nature of this new 21st century threat environment. The nations which do not support or believe in these values certainly have discovered the benefits of hybrid or fifth domain warfare. They are extremely active targeting our key infrastructure and our future prosperity through the theft of the best and most important intellectual property the country has to offer. They've also noted the ease and immediate benefits of undermining our democratic processes by undermining people's trust in institutions, as well as our ability to conduct respectful and constructive dialogue. There are a number of areas to explore in this discussion today, but first let me say that I've also been a long-serving and vocal advocate of increased accountability for the security intelligence community. The establishment of the National Security Intelligence Committee of Parliamentarians and the National Security and Intelligence Review Agency will now meet the majority of my concerns on the need to enhance accountability and transparency across the security establishment. However, as part of my opening proposition, let me now address more directly aspects of the threat and our need to effectively respond to that reality. We live in unprecedented times. Never in my career, which has spanned almost a little over 3 decades, have I perceived such a set of local and global challenges, from climate change and food security to irregular migration and unprecedented numbers of refugees, as well as social and political upheaval, nuclear threats, and shifting global hegemony. Threat actors from around the globe now target Canada with ease. Conversely, Canadians with the intent to harm others or target Canadian interests abroad can now operate from far-flung regions of the world and not just from typical conflict zones. In this security intelligence equivalency of globalization, it is critically important that CSE continue to support CSIS, the Department of National Defence, and law enforcement agencies in the pursuit of lawful investigations or mission requirements, wherever threats may emerge around the world. Whether it's to assist CSIS to collect intelligence on an emerging violent extremist network targeting Canadian travelers or diplomats abroad, to assisting the Canadian Forces in the protection of a deployed unit delivering training, or perhaps even helping the RCMP bring human traffickers to justice, we need to provide the best available tool sets. The tools or capabilities that I'm suggesting here are ones that only our signals intelligence organization can provide. Equally important, I believe it's critical that we rely on Canadian-controlled and accountable, or controlled and accountable capabilities, rather than having to rely on the efforts of, or the competencies of other nations that may not share our full set of standards and intentions. With respect to Part 3 of the Act, specifically dealing with cybersecurity and information assurance, let me say that as the Provincial Security Advisor for Ontario, this is the area of greatest concern to me. That is the cyber threat targeting our vast investments in critical infrastructure. Outside of the protection of intellectual property from either front door or backdoor acquisition, what is key to our current and future prosperity is the protection of life-sustaining critical infrastructure assets, be they publicly owned or in private hands. As such, the enhanced ability for CSC to provide assistance towards protecting our critical infrastructure is vital for Ontarians and I dare say for all Canadians. I believe this to be true as we now exist in a hazard environment where 400+ new malware threats are produced every minute, and where ransomware attacks a person somewhere in the world every 10 seconds. As localized proof, the Government of Ontario's Cybersecurity Operations Team manages approximately 40 billion security events per month. Yes, that's billions per month. Although we are within industry norms, over 90% of the emails that the Ontario Public Service receives are blocked due to botnet or spam threats. With respect to defensive cyber operations, I believe that only CSE can bring to bear the technology, know-how, and library of threats related to the data necessary to build effective cybersecurity resilience, so necessary in this kind of environment. From conversations I've had with private industry and with large independent agencies of government, such as those involved in energy, healthcare, education, and transportation, all feel the effects of constant cyber threats. In essence, we and they can no longer do this alone. It's a global threat phenomenon requiring a national-level strategy and capability. As it pertains to active cyber operations, let me simply say that the best defense always begins with a good offense. When more than 6 countries around the world are reported to be actively developing cyber operational capabilities, in my view, we must develop offensive cybersecurity measures to respond. And on certain occasions, that means beyond our borders. Offensive cyber tactics have been developed and are being applied by the best private security firms in the world. Engaging the so-called dark web or dark net to gather intelligence in advance of an attack to protect systems such as those in the financial sector has been the norm for some time. I know that because I've worked directly in that sector. Come a time when we'll face a targeted attack intended to manipulate the operating systems of an energy facility to cause a malfunction, or perhaps even to destroy something, as we've seen in cases from Ukraine to Germany and even a New York State, we will need CSE to, quote, degrade, disrupt, influence, respond to, or interfere with the capabilities or intentions, unquote, of those threat actions or their actors. More commonly, and as another example, the frequency and prowess of so-called denial of service attacks, or DDoS, events are intensifying. One day soon, I predict, a CSE will be required to assist a Canadian service provider or a subnational level of government to repel a massive DDoS attack. With the advent of the Internet of Things, we've already seen or witnessed botnets created out of smart devices being harnessed to launch 1 terabyte per second attacks against institutions typically associated to information sharing, anti-spamming facilities, social networks, human rights workers, and mainstream media. Rest assured, this will only get worse, especially when facing autocratic regimes around the world who have no inhibitions. On the issue of changing times, in my current role as Provincial Security Advisor, it's an important example of how the world has changed and how Canada's view of itself and how it operates must also change. Ontario is but one of 14 core jurisdictions in this country. By itself, Ontario's economy would rank 18 in a G20 context. No doubt, like Ontario, all subnational jurisdictions are conscious of the multitude of threats that continue to adversely affect prosperity and security. So to close, in my mind, an effectively legislated security establishment that balances security requirements with accountability, transparency, and the respect for the rights of Canadians is indeed the blueprint for future success as a nation in this increasingly tumultuous world.
Thank you, Mr. Boisvert. And now to the round of questioning. Ms. Damov, 7 minutes, please.
Thank you, Chair. Thank you to both witnesses for being here today. Ms. Vaughn, nice to see you again. My first question is actually to you, and I'm wondering I think you were here when I was asking CSE a question, and I'm wondering if you could respond to what I was asking. So if a Canadian or a person who resides in Canada and is abroad has a reasonable expectation to privacy, if that information gets caught up in what CSE is doing, do you think a ministerial authorization should be required?
It's the essence of our proposal here is to find a way to harness the accountability mechanism that is being proposed for all collection of Canadians' information, whether or not it hinges on this finding of a reasonable expectation of privacy. How are you ever going to get to that adjudication unless you have a mechanism, right? It becomes a circular argument. So certainly, because what is frequently collected in our understanding is metadata, if not a direct interception, which in our view certainly is one of the issues that is critical to maintaining Canadians' confidence in the proposals, then having more authorization accountability is always going to be better than less.
Do you think there's a misconception amongst Canadians when we talk about this, that they're thinking about people who are perhaps sending emails and making phone calls overseas and it's a terrorist talking to a Canadian who's plotting, versus, I know I didn't understand exactly how all-encompassing this metadata was until I was on this committee. But do you think Canadians understand how they can get caught up in that loop because they're on Facebook or they're on Instagram or Twitter or something like that, where things are being collected that they actually think is private and isn't?
Certainly, Canadians are becoming increasingly alive to the sense that what constitutes incidental collection, again, because of the nature of the communication networks, could very well implicate them. This is a growing awareness, I would say, in Canada, and it becomes problematic when we keep hearing. It's fair language to say that CSE doesn't target, but the way that the actual operations occur certainly implicates Canadians' data frequently. And so when I say it's not insignificant collection, again, this is something that Canadians are becoming increasingly alive to, and so they want to see the mechanisms be robust enough to provide the kind of assurances that would be protective of them.
And while I agree with you, I think if more Canadians understood what's actually being collected, I think you would have more Canadians speaking out about it. Which does bring me along to data collection, and I'm wondering, and I know you've spoken to this in the past about data collection, how long it should be retained, if there should be mechanisms for destruction of data that's collected. I'm wondering if, if you believe that there should be an amendment to the bill to the effect of introducing a necessity threshold for the retention of personal information, as well as a destruction obligation for personal information that does not meet the necessity threshold, would it help to increase transparency and protect individual privacy?
Is that question related specifically to CSE, the proposed CSE?
The bill in its entirety, in the bill itself. Because CSE that's collecting data, right?
That's right. There's a number of aspects of data collection that are touched on. I think in the main, depending on the kinds of collection, certainly introducing elements of necessity are clearly of privacy benefit to Canadians. In terms of whether or not that's appropriate across all of the channels of data collection, there may be some standards of variation that we would suggest are nevertheless appropriate. That said, the piece here about that you're asking about, the retention, is a very interesting piece, and it's part of this sense of where you have compounding low threshold authorizations. And it's the point that we make about simply compounding the first mistake of having an insufficiently high threshold in the beginning to say, can we retain this on some kind of might prove useful standard, compounds the first problem as opposed to addressing the problem, which is the fundament of what we're saying in relation to retention.
Thank you. I wanted to talk about reporting. And just wondering if you see a benefit that the Intelligence Commissioner should be mandated to produce an annual report about the activities in the bodies that it oversees, and also if you think that it would be beneficial that CSIS publishes an annual report.
Certainly, I would say we have found, for example, the annual reports from CERC and the CSE Commissioner to be immensely valuable. I can't, if we were going to make a recommendation, over-reporting as opposed to under-reporting would absolutely be the direction we would want to go in for accountability and maintaining trust.
Okay, thank you. I have slightly less than a minute left, I think. Is that right?
That's right.
Mr. Boisvert, I don't want to leave you out, so maybe this will be a fairly quick question, but I know some of the testimony we heard earlier about C-51, that the new offense of advocating or promoting the commission of terrorism offenses in general was so general that it was actually impossible to prosecute under. So when the minister was here, he talked about changes to it so that charges actually could be laid. And I'm wondering if in probably 30 seconds you can give some brief comments on that.
Well, certainly in my time at CSIS, although now dated, it's been almost 6 years since I left, but when I was responsible for the counterterrorism operations team, a number of charges were difficult in this very, even more complex choreography around intel into evidence. In other words, proceeding against certain targets that met the CSIS threshold of reason to suspect, versus then transferring some information, protecting sources, which of course Bill C-59 provides new tools to assist that in some respects. But it would left many operational opportunities wanting, because one, we had difficult transitioning information from intelligence into usable evidence. Secondly, quite often I found the perspective of Crown prosecutors is always extremely cautious, which I think as a Canadian is a very important thing because it adds one more check and balance. But definitional things, and I think generally a very, I guess a prosecutorial system that is really inclined to ensure that there is very little chance that this prosecution could not proceed successfully. So I think more often than not, cases end up dropping below the threshold, even though I think perhaps in another jurisdiction south of the border, perhaps as one example, it would have proceeded full guns.
Thank you, Ms. Damoff. Mr. Paulus, so 7 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Thank you to our witnesses. I'll start with you, Mr. Boisvert. We're going to talk about Islamic State a little bit. They've lost a lot of ground in Iraq, but they've started operations now with cyber attacks. In 2017, there was a report made public that showed that Daesh was using cyber attacks to target people that they wanted to kill and to get information from random people. Do you think that right now that's what we should focus on when we're talking about the threats from ISIS, this kind of control? I would say no. I'm more concerned about cyber attacks because, as I explained in my introduction, there's so much more direct danger and threat to our society, to our prosperity now and in the future, because what often happens with anti-terrorism activities is that the actual repercussions of terrorism are exaggerated, amplified, compared with other threats. And we know that there is limited effect of those attacks. When we let's talk about China. Just recently in Le Monde, there was information about the activities in 2012. They used operations to take information in massive amounts from Africa to China. Our government, as we know, is trying to strengthen our economic ties with China, but we know that China is a major player when it comes to cyber attacks. Do you agree? Yes, I would rather respond in English because I want to make a comment, and I work mostly in English now.
The threat capabilities of Russia that have been demonstrated either through the interference in democratic processes through Western Europe and in the United States and increasingly in a number of specific states in the U.S. And its malicious intent and its supporting autocratic regimes from Syria and elsewhere are clear. Those are much more predictable and traditional types of quasi-military and the hybrid warfare threats we've seen them conduct. So it's using everything from proxies, definitely using internet type of attacks, and using in convergence with organized criminal groups in Russia, launching a number of important negative effects on jurisdictions, including Canada. China is a very much more complex issue, and I understand the challenges of jurisdictions like ours nationally. State-owned enterprise is now authoritarian capitalism seems to drive a lot of business opportunities, a lot of business decisions, but they represent complexities that I'm not sure as Canadians we fully examine from time to time. There's also the issue that I think it's China is now in the age of self-admitted sharp power, and they exercise that power with very little reservation anymore. There's no longer even a question of hiding their intentions. They are taking a very aggressive approach around resources, around intellectual property, and they also are very clear about dealing with dissidents and academics, and they've arrested and they punish others, including academic institutions in North America, at their will. So I think there's a value challenge I think Canadians must have to consider along with the economic opportunity discussion. So I think the Cold War of the past is over, but I think a new version of that is rapidly emerging, and I think our focus on counterterrorism is not always in our best play.
Justement, on parlait de
We were talking about war. I think it was Pan that asked the question actually earlier. The malicious actions by China against Canada, you talked about the best defense being offense. Can we take offensive action here in Canada to protect ourselves, or is it too complex? I know it's complex, but what kind of action can Canada take to protect Canadians? Well, we do need to be offensive in a hyper-competitive world. We are dealing with foreign entities that do not follow the rules. They don't have the kinds of organizations that Madame Vaughan represents to keep people accountable. There may be a cyber attack against one entity in Canada. Will that be from a foreign government, from a foreign agency with connections to that government? We need to be able to identify the operations, the computers that we can remove from the international communications networks. In that case, the government was criticized when we brought in C-51, but a point that is often raised is Canadians' rights and freedoms that have to be protected. We have to protect those rights. Do you feel that C-59 is going to dilute those protections too much?
Appreciate the work that Ms. Vaughan and her colleagues and other organizations in Canada and Western democracies do. It's an important part of that debate and discussion. But quite often I do feel a little concerned that we often spend so much time focusing on what are, I believe, organizations that operate by the rule of law, they're subjected to multiple layers of review, including everything from traditionally from the Auditor General to the Privacy Commissioner. We have now a number of additional bodies, which, as I said, I've welcomed. I think we live in the age of transparency and accountability, and agencies to operate with these special powers must accede to. But I also think that sometimes we forget that, well, as we focus on the incidental collection of some Canadians, and it's, in my view, despite the characterization, is not massive. I know from my time it was very, very minuscule, but it's incidental. It will happen because of the sort of convergence of all the global information infrastructure, the communications infrastructure. It does occur. Yet Canadians don't seem to having the same debate about all of those data brokers out there that have hundreds, if not thousands, of unique identifiers about them. And sometimes I wish perhaps Mrs. Vaughan's organization and others would focus a bit more on that, just to have some sort of sense that Canadians need to look at their data and their privacy and their personal information, not worrying about the security establishments as much, because they have rules of engagement and overview and review, but those who don't.
Thank you, Mr. Palouse, Mr. Boisvert, Mr. Dubé.
Yes, thank you, Chair, and thank you both for being here. It's interesting, given the comment that was just made about incidental information, because there's incidental information, there's the publicly available information, there's this notion that there's clearly an intent in the legislation to expand the powers for this threat that's being described. But when we ask the chief of CSE to explain why those powers would be used, there's no example that is able to be provided. And so I just want to, and this question is for you, Ms. Vaughan, just understand, because there's a link here. When we look, one of the answers that was given to me when they were before the committee, these officials, was about, well, don't worry, if you look at in Part 3 of the bill, paragraph 25, that they have to ensure measures are in place to protect the privacy of Canadians. But that's a very vague notion, because then it goes on to say, in the use of Canadians and of persons in Canada, in the use, analysis, retention, and disclosure of, and then goes on to describe the information. The use of the word disclosure is particularly troubling because that's how the government has rebranded the information sharing that was created under former Bill C-51. And so I'm just wondering if there's some concern about that information seemingly being for research and other innocuous purposes by CSE, but can nonetheless be shared, and what consequences there are there, and in particular being shared with Five Eyes allies when we see examples like what was reported in La Presse last week, or at the end of last week, about how the RCMP is acquiring information on Canadians from the DEA without the proper judicial oversight that would normally be involved if they were doing it here in Canada. So with that very broad portrait I've kind of painted, I just want to understand, because I think a lot of people don't quite understand how maintaining, even with the cosmetic change, information sharing as was brought in by the former Bill C-51 has an impact on how these new powers of CSE are going to potentially play out.
Yeah, thank you. It's of critical concern to civil libertarians that we have the public understand that collection, incidental or otherwise, of personal information into national security agencies, even with the notion, perhaps we're not exploiting this, perhaps we're not using it in ways we're going to try to give assurances, is not innocuous. In part because we do have these alliances, information sharing does flow in ways that are potentially problematic for those individuals. We don't actually know what's being used in terms of exploitation. We know it's everything from network mapping to profiling, which has been identified as a huge problem and Canadians definitely resonate with as a threat to their own personal security. So all of those aspects in terms of trying to figure out what the jeopardy is for this collection, use, retention, and exploitation is critical. So figuring out those tentacles and ensuring that we have mechanisms that are not merely paper mechanisms where we say we have measures. What are those measures? How do we know where they work? Do they cover off all the aspects? Those are aspects of the behind the curtains that goes on with national security that most Canadians cannot see, and we've come to have reason to distrust because we haven't seen, for example, the simple definitions for things, allowing us to have the insight that we should have for democratic accountability. So when we see failures of definitions in C59 around things like publicly available information, to pick up my colleague's point here, if you can acquire as a national security agency through a data broker using the kinds of techniques that were just being described and ingesting that into a system in which information may get shared with allies abroad, again, you can see the magnification effect of the impact on security of individuals, not national security, but personal security in relation to all of those data practices. People are not as alive as we would have them to be to these threats, but they are increasingly alive that these are the problems as you illustrate.
And what role, and perhaps I'd like to hear from you both on this, you know, there's a lot of, the word information infrastructure gets thrown around a lot. It does seem to have a, there's a definition there, we can debate that, but this notion that the definition of a foreign entity being attacked or information being collected on them by CSE is not the same as it was when the CSE Act first came in. And these information infrastructures, and I'm thinking in particular of Ms. Damoff's questions over the last two witness panels about this notion that and even when we look at telecommunications companies in this country, we would have blinders on if we believe that things like LTE networks and stuff like that are being developed in a silo. There's obviously international efforts that are going on to make these networks better and more robust, but while that's happening, these legal definitions of what's happened, it just seems that it's a bit out of date in terms of what's foreign and what's not. And as soon as we're giving the power for the minister, for example, to identify information infrastructure, inevitably that net's going to be wider than it ever was before. And I'm just wondering what both your thoughts are on that. Perhaps we could start with Mr. Boisvert and then go back to Ms. Vaughan.
Question. Unfortunately, Mr. Dubé's left you a minute to answer it, so if you could be very brief.
Well, yeah, it's going to be very difficult. It's a very complex world. It's getting more complex. Data is growing exponentially. It's a two-part play. One part is the opportunity technology will allow us to do many, many things. The second part, of course, it's just an enlarged threat surface for attackers to focus in on and to break into those same networks to steal personal identifiable information the same way as is being suggested. Perhaps the security establishment can, under warrant, predicated investigation, lawful work, go in there. So we have a big problem around data and around privacy and about the invasion or the loss of security of the person, and it's occurring as much, if not more, from the threat actor side than I think in terms of security agencies and others. But I'll give you some time.
Just quickly, I mean, you see the tension around this when you give the CSE broad active cyber powers that exploit vulnerabilities in a system that, of course, Canadians require to protect themselves against. So are you going to disclose those, or are you going to exploit them? It's one of the tensions inherent in this new power.
And if I may, just really quickly, like 20 seconds.
20 seconds.
When I lent myself to the exercise that CBC Réseau Canada did with cell phones and CSE not commenting on what that does for public confidence, is that potentially because those same loopholes are being exploited and inevitably there's that risk?
You're going to have to work that into another answer. I'm sorry. Mr. Fragiscatos, 7 minutes, please.
Thank you very much, Chair, and thank you to both of you for being here today. Mr. Boisvert, I want to start by talking about cybersecurity and offensive capability. In your presentation, you talked about a community of like-minded nations coming together and taking cybersecurity very seriously for a number of reasons, not just for from a public safety perspective or a traditional national security perspective, but also for the defense of basic democratic principles. I wonder if you could talk about where we are, where CSE is, I should say, in terms of what's being proposed here for an offensive cyber ability, how that compares to other not like-minded, but other middle powers, if I could. I won't talk about the U.S., but for example, Australia, the Australian Signals Directorate, the equivalent to the CSE, has an offensive cyber capability. In New Zealand, the Government Communications Security Bureau, that is the equivalent to CSE there. It's not directly involved in mounting an offensive cybersecurity strategy, but that is in effect conducted by the Defense Force. So that's in place there. Where are we in terms of our Five Eyes allies? Let's look at what they're doing and compare that to what we're doing.
Well, at the present moment, I think we're on the low side of response in terms of investment, and I think in terms of empowerment for the security establishment to respond. I think that may shift. We have a pending government cyber strategy, which may maybe boost us into a new sort of level of the atmosphere. But currently, I think Canada is seen being somewhat trailing its key allies from the United Kingdom to Australia, New Zealand, and elsewhere. To me, that's very problematic, of course, because my responsibility as the Provincial Security Advisor is to, of course, help or assist in certain strategic issues around the prosperity agenda, but mostly it's around protecting critical infrastructure and around cybersecurity. And with that in mind, as I said, they cannot do it alone. That is those who own that critical infrastructure, some of the large independent agencies of the Ontario government in that, let's say, healthcare sector, education, transportation. We need to bolster our capabilities to make ourselves on par, I think, with places like Australia.
Okay, I'm glad you mentioned critical infrastructure because I wonder if you could tell us how a offensive cyber ability allows us to protect critical infrastructure. You've been very public about concerns around hydro and nuclear power stations, but also healthcare systems. Attacks. Hacking attacks on meant to retrieve personal and private information from Canadians or basic R&D data. How critical is an offensive strategy, an offensive capability from a cybersecurity perspective in protecting all of these things?
Well, first, let me affirm, too, that it's really important to understand that the healthcare sector in general is the most targeted area now of governments around the world. Right up there with .mil and .gov domain addresses, most healthcare sectors are under attack. Why? Because data is the new oil. It's the most expensive and most sought-after commodity in the world, and threat actors from all varieties, all types are converging upon that. Those are also arguably the least defended sectors of our society, unlike the large government, military, and other sort of sectors. So I think we need to rapidly move to a place where we can call or bring to bear some of those cyber offensive tools. To one example would be to go out into the dark web consistently and look for early indicators of compromise. Look for where threat actors are talking about you, talking about your domain, talking about your strategies as early opportunities to get at that. There are also the opportunities in a sort of offensive way that should a massive DDoS attack, as we've seen against places like Spamhaus and against New York Times and other organizations, and they are amplifying in size, is that without the aid of large agencies, those particular important aspects of our democratic societies will fall. So it's about going out there, targeting those servers, of course, consulting with the Minister of Global Affairs, and of course with the approval of the Minister of Defense, and hopefully exercising some sort of kinetic effect on those servers and taking them offline.
No, I appreciate that. So you've been very clear about the importance of securing critical infrastructure. It was already asked by my colleague opposite, the threat of Daesh, for instance. The pendulum swings and has swung over the years, particularly after 9/11. There was an emphasis on radical Islam, if I can put it that way, and countering that particular threat. But when you consider how important it is to secure our critical infrastructure, can you go over what you said, in fact? Because my understanding is that if we're listing threats and we're ranking them in terms of danger to our national security, do you think that critical infrastructure is a more important area to focus on right now than what we've been looking at in the past after 9/11?
Yes, as I was saying earlier, terrorism is effective because it terrorizes. It has a disproportionate effect. The number of Canadians adversely affected by a terrorist event is very, very, very small. Conversely, though, it's everything that sustains our life. It's the heat, it's the lights, it's the food at the grocers and the petrol at the service stations. All those fundamentals that allow us to exist are all now increasingly built on systems, automated systems, and machine learning, and interconnected interdependencies across the board. That's why those are at risk. They're at risk mostly in the age of fifth domain warfare. So we went from land to sea to air to space, and now it's about cyber. We'll probably not see another debate over an F-35 again, because most of that money in most jurisdictions is moving towards information warfare. So, and what they will do is, that they've done in Moldova, as Russia's done in Moldova, as they've done in Ukraine and elsewhere, or in Georgia, you go after and you signal. You might just take out something small, something a little bit bigger, than something threatened to be cataclysmic. And I think that's really where the big threat is. Terrorists using cyber tools, not so much yet. Is Daesh going to go from managing or dominating social media to tuning their skill sets towards attacking? I think that's very possible.
Thank you, Mr. Fragiskatos, and 5 minutes for Mr. Palus and Mr. Iglunski. I'm going to take the immense power of this position and allow Mr. Spengelman of the final 5 minutes, even though we'll have gone past time, if that's all right with colleagues. So 5 minutes for the two of you.
Monsieur le Président, merci. Je vais faire ça rapidement.
Thank you, Mr. Chairman. I have a quick question for Mr. Boisvert. Do you have any concerns about the fact that Canada is taking a laissez-faire approach to Chinese investments, especially with respect to high technology? They want to take over our systems, especially satellites. Well, this is a complex domain because Canada wants to take new economic opportunities. There are negotiations underway with our North American partners. China represents a real opportunity, but we have to go into these negotiations or talks with our eyes wide open. We have to look at investments in certain sectors, and I do have some concerns about investments in high tech and so on.
Community is critical to Canada's intelligence community. What are the consequences if new reporting and regulations reduce our capacity to do that?
Well, I think, and at least again in my time at CSIS and within the intelligence community, I think Canada was always a very powerful and respected net contributor to the group. However, at times it may have changed. I think at the end of the day, as I said earlier, I'm inclined, and I believe we're in a new era. Things change all the time. Legislation has to change. We need to improve our ability to respond to new technological advances. Equally, though, I think in the age, we're still in part of, I call it the post-Historia Ed Snowden age. Once we get through that, nevertheless, society will have been transformed. He was a consequential figure. I recognize and I respect that. So therefore, we're in the age of accountability and transparency. Having more layers, I don't think, as long as you have mechanisms such as emergency powers to invoke, as the chief of CSE has, I think that's fine. So I guess I wouldn't want to respond to any alarmist comments that we'll be stuck and won't be able to respond effectively. I think it's a pretty good balance overall.
Do you think this could put Canadians at risk?
If C-59 is passed in its current form, or if we have more layers?
In relation to my first part of my question.
Yeah, no, I think C-59 again is a good balance. I think Canadians will be better served by it, and I think we'll have a better or as good of an opportunity as in the past to deal with emerging threats. Okay.
Does the increase in the reporting pose an issue for operations if more money goes towards administration? Do you see any?
There's no doubt there's a cost, and that cost could be a nimbleness. I always have to measure that. I think of it as a moment in time when I was responsible for the counterterrorism sector, the principal one. I had over 30% of my management team were involved in Security Intelligence Review Committee hearings and security certificate hearings, and at that time, about 87% of our staff had left less than 2 years service. That was one highly risk-managed environment, and we had a number of kidnappings. We had Robert Fowler, Louis Gay, Amanda Lindhout. We had probably half a dozen kidnapping cases around the world running at the same time. It's tough. So if you add more layers, you should probably think about the resourcing question around trying to ensure that we do not affect operational capability.
Okay, thank you. On November 20th, I spoke in the House on Bill C-59, and I talked about Part 5. Where it was amending the Security of Canada Information Sharing Act, and we have heard and read repeatedly that information sharing and breaking down the silos for information are critical to protecting Canadians. Do you believe this Bill 59 is increasing or decreasing our ability to share information?
Well, let's just say we've gone from almost zero capability to considerable capability, now back to perhaps something a little less than perfect from, I guess, from a security practitioner, not from somebody, of course. Ms. Vaughn, and I would take her points on that. You really have to be careful about this. I'll share a quick anecdote. I was posted to the Middle East, early 2000s. Suddenly, one of the employees at the embassy comes to me and says, you know, there's a Canadian passport. We had lots of serial losers of passports. And he says, this one passport's popped up in 5 different countries in the last 6 months, it seems, because we're getting reports, yet that person's supposedly still living in this country. So I said, okay, can I get their name? Can't do that, sorry. And so anyhow, we end up having a long debate, escalated up to the ambassador, all the way back to Ottawa between Foreign Affairs and CSIS, and I don't know if that ever got resolved. To me, that was the worst example of how things used to be, and we can never go back to that because Canadians, the lives of Canadians will be put at risk.
Thank you, Mr. Glinski. Mr. Spingleman, final 5 minutes.
Thanks very much, Mr. Chair, and thank you for being here. Ms. Vaughn, you're joining us during the week of the 1-year anniversary of the shooting at the mosque in St. Fort, Quebec, and the country is still coming to grips with this incredible tragedy. And I'm wondering if you could, just in a very general way, give us your thoughts on where you think Canada is today with respect to the balancing between civil liberties and providing good security. Perhaps from an organizational lens, if you have data to back up Canadian opinion, but more personally, where do you think Canadians are vis-a-vis prior to January 1st of last year?
Thank you for the question. I hope it's appreciated that the Civil Liberties Association takes security very seriously. The importance of getting these rights and freedoms of Canadians to fit together with the ability of the government to provide national security protection occupies a great deal of our bandwidth to get this correct. Canada, as you may know, was really, to use some of the language that has already been introduced, a bit of a laggard in a number of arenas, including having the kinds of transparency and accountability mechanisms that are standard in many of our allies, countries, present here. And so we welcome the ability to enshrine in legislation and make more transparent the accountability that is needed for Canadians to trust that national security is working in their interests. So we have advanced in that regard. Our concern about C-59 is that there's a sense in which this is the moment to get the big pieces right. And so when we bring forward our concerns about the thresholds for bulk data surveillance, which has never been appropriately debated at a parliamentary level, we are saying that we welcome this opportunity to put the big thinking together in relation to these pieces, but in part because we have an omnibus bill before us, some of those aspects are being given insufficient attention.
Very briefly, one of the sets of provisions that's very important, it's near the end of the bill, but it's are the ones dealing with youth, 159 to 167. They bring in the Youth Criminal Justice Act, and youth in many respects are vulnerable. I'm wondering if you could very quickly give us your thoughts on whether you think those provisions adequately protect the privacy and personal interests of Canadian youth.
Could I get back to the committee on that? Because I feel speaking of insufficient attention, I have given insufficient attention to that particular aspect of the bill being focused on other ones, and we'd be happy to share our views with you.
I think it would be helpful. Mr. Boisvert, if we can take advantage of your position, you'll have a lot to say about this. Canadian youth are vulnerable not because they're youth, not only because they're youth, but also because they're preyed upon by terrorist organizations like Abu Sayyaf, like Al-Shabaab, like ISIS. And I'm wondering if we could have your perspective on the protection of Canadian youth with respect to terrorist organizations that prey upon them as related to the provisions that are captured in the bill.
Well, certainly, I'll speak more perhaps at a higher level and from a practitioner's perspective. And no doubt, and I'm not one, I'm part of the school, I don't blame the internet for radicalization, but it certainly is an important pathway and part of an ecosystem that leads to somebody falling prey to negative messaging. I'd also like to underline, too, as it's just been recently underlined once again in the United States in a more recent study, is that the biggest threat of radicalization is actually the extreme right and not Islamic extremism. And I think that's a very important piece. Radicalization or extremism is extremism is extremism. It's the idea that we're now increasingly living in a world that we're able to purvey hatred, and we can entice people, we can motivate them. The challenge for the security agency is that they'll quite often, that person will come to their attention sometimes, quite often through the issue of data exploitation, and quite often through the issue of people post online. Aaron Driver, the case in Ontario just about a year and a half ago, is a great example of that. So that's still an important tool set. The question is, when does somebody go from actually becoming radicalized and becoming incensed and thinking about, maybe making some comments about mobilizing towards operational planning, but knowing when they really intend to do it? And that's the big dilemma between the intelligence agencies and the law enforcement groups like the RCMP that work together on those cases.
Remaining time is very limited, but a very brief question, if I may.
13 seconds.
You'll be the perfect person to answer that. Somebody, a Canadian youth who has been inside a terrorist organization and comes back onto our shores. What are your views?
I think it's going to be a difficult and expensive process because, one, it's difficult to understand when somebody's been exposed to extreme levels of violence, once they've been highly radicalized and they've been schooled in warfare. You hope that they've just had enough, they've seen it, they made a terrible mistake, and I think probably the majority are exactly in that kind of mindset. But how do you know? If my responsibility was still to keep Canadians safe, responsible for a counterterrorism program, we'd saying, well, we have to run this to ground to make sure that, let's go out and speak to that person as often and as frequently as we can and get a better sense of what's behind their motives and have they turned the corner or whatever. The expensive part is you still have to afford some level, I think, of coverage in the early portions of that, but you can't cover everybody. The number of persons who are of concern greatly outstrips the capability of the security establishment back in 2012, and I hate to even think of what it is today.
Thank you, Mr. Spiegelman, and I hate to bring this conversation to a close. On behalf of the committee, I want to thank you for your thoughtfulness, and with that, we're adjourned.